Welcome everyone. In this video, I will introduce you to the Court of Justice of the European Union. This institution is the judicial body of the EU, and it has had a significant effect on the development and political direction of the legal order of the EU. In this video, we will discuss the historical evolution of the Court of Justice of the EU. In the next video, we will zoom into the internal organization and discuss the roles of the two courts under this institution. But let's first have a look at the historical evolution. In 1951, the court was set up as part of the European Coal and Steel Community. The court consisted of 7 judges, 1 of each of the 6 member states, and the 7th seat rotated between the large member states. The function of the court was to ensure that the member states would observe the law in the interpretation and application of the treaty by which it was founded. With the creation of the European Economic Community and the European Atomic Energy Community in 1957, the court became a common court for the 3 communities, and it was named the Court of Justice of the European Communities. For more than 2 decades, the Court of Justice was the only court with jurisdiction. However, the considerable increase in volumes of disputes soon resulted in a trend of legal backlog. To reduce the Court of Justice of parts of its caseload, the Single European Act included a provision to establish the Court of First Instance. The creation of this court had 2 advantages. On the one hand, it allowed the Court of Justice to focus on its most fundamental task, namely to ensure the uniform interpretation and application of EU law. On the other hand, it improved the protection for EU citizens, since the 2-level jurisdiction now allowed for appeals against first-instance rulings. With the creation of the European Union under the Maastricht Treaty in 1992, a number of amendments were made to improve the efficiency of the institution. New competences were given to the court, and the scope of jurisdiction was broadened as well. It is important to note that the common foreign and security policy and legal acts concerning cooperation in the fields of justice and home affairs did not fall under the responsibility of the Court of Justice. It was only with the Amsterdam Treaty that this substantially changed. This treaty provided that the Court of Justice should, under certain conditions, have jurisdiction within the 3rd pillar. Issues in relation to immigration and asylum policies and to police and judicial cooperation that were previously settled on the member state level now fell under the jurisdiction of the court. The pillar structure was eventually abolished under the Treaty of Lisbon of 2007. Unless the treaty provides otherwise, such as in the domain of CFSP, the court has now general jurisdiction. Moreover, the Court of First Instance was renamed into the General Court. For the full list of amendments introduced by each treaty, please have a look at the website of the Court of Justice.